Hello. Okay, now we got it. Well, Samba was almost better than patents, but we can start. Okay. I'm listening to something else. I'm sorry for that. Welcome you all. We're here today to speak of Unified Patent Courts, which is probably the biggest development in patent law we've had so far over the last decade or so. And for that purpose, we welcome here in the name of BPI and our president, Gabriel Leonardo's, Dr. Klaus Grabinski. Klaus Grabinski is president of the Unified Patent Court since November 2022, and he's been federal judge at the Supreme Courts of Germany in civil and criminal law matters, and he's been a judge he has a very extensive resume. He's author of several books. He's a lover of poetry and what was that? Mountaineering as well. He does hiking, and he's a very, very, very important figure in Europe, because he's also president of, and I said president of, the Court of Appeals of the Unified Patent Courts. And we also have Howard Reed here. He grew up in Brazil. He's he speaks fluently Portuguese. He's an European patent attorney and a litigator. And he specialized particularly in patent oppositions and appeals before the European Patent Office, and in patent infringement procedures in the UK courts and at the new Unified Patent Court as well. In the name of us all, I welcome you both and would like to invite Klaus to the stage.
Leticia, thank you very much for this kind introduction. Good morning to everybody. It's a great pleasure being here in Rio, and it's a great pleasure and honor to have been invited to this wonderful conference and to have the opportunity to tell you a bit about the Unified Patent Court. We had a wonderful evening on Sugarloaf yesterday, and from there we had a wonderful view on Rio. And what I try to do is also to give you, I don't know whether it's wonderful, but to give you a view, an overview on what the UPC is like. So sometimes it's good to look back in order to better understand things. And you may ask the question, why does Europe need a new patent court? And this can be best understood by looking back to the situation before 1st of June, because on 1st of June the Unified Patent Court Agreement came into force, and at the same time also the regulation of unitary patent protection came into force, and it is good to look back in order to understand why this happened. So, state of play before 1st of June 2023. What was the European patent system like at that point of time? Well, the good thing was that in order to get patent protection in Europe, it was not necessary to file national patents. Of course, you always could file for a national patent, but then you would have to go in parallel to all the member states of the European Union and all to other European states. Like France, you would have to apply for a patent in France, you would have to apply for a patent in Germany before the German Patent Office, and so on. And of course, it is much better if the system would consist of a one-stop shop only system. And this was already been contemplated and set into place in the 70s, that there is only one office for most of Europe where you can go and where you can get patent protection for all of Europe, even though Europe has so many states. And this office is the European Patent Office that was founded on the basis of the European Patent Convention, and the European Patent Convention came into force in 1977, so 46 years ago. And since then, in order to get patent protection in Europe, inventors have to go to only one office, the office in Munich. And that, of course, makes things easier for inventors. Now, what is a European patent? A European patent has in each contracting state of the European Patent Convention, for which it has been granted, the effect of a national patent granted in that state. So essentially, it is a bundle of national patents. The European patents, once it has been granted, gives you protection in France like a French patent, in Germany like a German patent, in the Netherlands like a Dutch patent. Provided, of course, the patent has been validated in the respective states. So you have to pay the renewal fees in the respective state. So quite some costs are involved, but what the takeaway is, so the European patent essentially is a bundle of national patent. The beauty is you only have to go to one office for all of Europe. Now, patent prosecution, the granting of a patent is the one side of the coin with patents. The other side, of course, is the enforcement. Because a patent that cannot be enforced isn't worth anything. So how to enforce a European patent? Since the European patent is a bundle of national patent, essentially, in practice, to enforce a European patent, you have to go state by state. So when an infringement happens in France of a European patent, you have to go to the French court in order to sue the infringer for patent infringement. And when the infringement happens in parallel in Germany, you also you have to go in parallel before the German courts to enforce your patent. And so, in practice, we have seen many times in the past parallel litigation about the same patent in a number of EU member states. There are a few exceptions to this, but essentially this was the practice in the past. And so the idea came up that there is a need not to have only a one-stop shop in the granting of a patent, but also with regard to enforcement of a patent. And that is essentially why politicians, but also stakeholders, were very much interested in having a court for Europe, a patent court for Europe, so that you can avoid to go in, that you have to go in parallel to enforce a European patent. And the court that is supposed to do this is the Unified Patent Court. And as said, the court opened its doors on 1st of June of this year. So what is the concept of the Unified Patent Court? The Unified Patent Court essentially is a court common to several member states. I have to say, it is not all the EU member states. The EU currently has 27 member states, and out of the 27 member states, it is 70 member states that are contracting member states to the Unified Patent Agreement, so participating member states. This encompasses Germany, France, the Netherlands, Sweden, just to name a few, Italy, just to name a few. When you look to the gross national product of the whole of the EU, it covers 3/4 of the EU gross national product. So it is economically by far the largest part of the EU market that is covered by these 17 contracting member states. And the concept is that the UPC is a court of all these 17 contracting member states with regard to European patents. So the court is at the same time a French court, a German court, a Dutch court, a Swedish court, and now I could name all the 17 contracting member states. And on this background, when an infringement in parallel, alleged infringement is happening in France, in Germany and in Italy, before you had to go to the national courts, so to the French, Italian and German national courts. Now, when it's about the infringement of a European patent, you can go to just one court, the Unified Patent Court, because it is the court for the place of infringement in France, in Italy and in Germany. And it also has the power to decide on the validity of the patent in France, in Germany and Italy and all the other 70 member states, because it is a court of these countries. So that's essentially the concept of the UPC. Now, there are some stakeholders, however, that don't like the new court. There may be different motivations for this, but one might be, okay, it's a new court. It may take time until it really works properly. We don't know about any decision at the moment because it's a new court. It has to develop, so we do not want to be part of this. That, in order to satisfy this, these stakeholders, these holders of European patent, it was possible, or it is possible, during the first 7 years to opt out the European patent from the UPC system. So these stakeholders that are skeptical about the UPC, they had and they have the opportunity to opt out the European patent and the European patent application. So, so the effect of an opt-out is that for these patents that have been effectively opted out, everything remains the same. As I explained to you, the situation before 1st June 2023. Everything remains the same. And in practice, there are roughly about 1.5 million European patents and published European patent applications out in the air, and out of these 1.5 million, a third has been opted out. And the expectation is that there will be no more, because there was a reason to do this very early, so to avoid having litigation in the UPC. Because when you do it now, and you haven't, that you would have run the risk that you still would have litigation in the UPC. So for that purpose, we do not expect more, at least not significantly more, opt-outs in the future. So this means potentially 1 million patent or patent application that, of course, published patent applications that may become patents are under the jurisdiction of the Unified Patent Court. However, even if the patent has not been opted out, also during these 7 years, the patent holder can decide whether he or she wants to bring the patent litigation before the UPC or alternatively still before the National Court. When they bring it before the National Court, they can only litigate the respective national part of the patent. When they bring it before the UPC, they have the advantage to litigate all parts of the European patent. All parts of the bundle patent. And just to give you one more number, from the start, which as said, of the court on 1st June 2023, we currently have 50 cases pending before the Unified Patent Court already. And Howard will give you more details on this later during this panel. And then there is another patent that is called the unitary patent. So I talked about the bundle patents. The unitary patent can be granted also as of 1st June 2023. And the unitary patent, to be more precise, is a European patent with unitary effect. So it is always a European patent, but unitary effect for the 17 contracting member states. So that is particularly interesting for patent owners who want to save money. Why? Because when you take a bundle patent and you validate this in all the 17 contracting member states, you have to pay fees in all the 17 contracting member states. While when you go for a unitary patent, you get protection in all the 17 contracting member states, but you have to pay fees that are roughly about the fees in 3 contracting member states only. And also very, very reduced translation requirements. Almost no translation requirement. So that's the beauty of the unitary patent, and already, as to my knowledge, about 6,000 to 8,000 unitary patents, so European patents with unitary effect, have been granted. And for this unitary patent, it is only the Unified Patent Court from the start who has competence. Now let's have a look at the court. How does the court look like? What you see here is a picture of the structure of the court, and you see the court has a court of first instance and a court of appeal. And the court of first instance splits up into different divisions. So we have local divisions, we have regional divisions, and we have one central division. The central division is located in Paris, but has also a place in Munich. That's how Europe works. You always distribute things to different states. So in this time it is Paris who has is the seat of the central division, but Munich is a so-called section of the central division, and in 1 year time there will be another section in Milano. And the Milano section will, at least to some extent, replace the London section, because before the UK withdraw its ratification from the UPC agreement, it was provided that London should be the place of the second section of the central division. But since the UK left, now it's going to be Italy and Milano. The local division essentially is a division of the Unified Patent Court hosted by one member state. And I will show you in the next slide on a map where these local divisions are located. And then there is one regional division that is a division that is shared by a number of member states. And there's one regional division only at the moment that is shared by Sweden and the 3 Baltic states. And this regional division is located in Stockholm. And as this is a European court, the European court, with regard to the interpretation of EU law, has, like any national court, has to follow the European Court of Justice jurisdiction. And that is, you can see it on the left side of the slide, there it is expressed. So when a question of EU law comes up, which is not clear and has not clarified, then the UPC will have to make a referral to the European Court of Justice to clarify this issue. That is not different. That's like all national courts have to do. The same in the EU. And then there's also, to make the story complete, there is a patent mediation arbitration center. So then when there's a need to settle a case, but also judges can help to settle a case. But if parties would like to have the case referred for settlement to the patent and mediation arbitration center, that can happen too. And the next slide, you see the full picture of Europe. And what you see is in the dark blue, these are the contracting member states, those that have signed the UPC agreement and ratified the UPC agreement. So where it is in force since 1st June 2023. The states in a brighter blue are those that signed the UPC agreement but have not yet ratified it. But for them it's always possible to join by ratification of the agreement. So if you ask me for a guess who is going to join next, my guess would be Ireland, because Ireland, they need, for constitutional reasons, they need a referendum. And they are preparing a referendum. They don't want a referendum only because of the UPC. They want to combine it either with the next election for the EU or Parliament, or with another issue for a referendum. But this is going to happen soon. And practically this could also mean, since many UK lawyers, in order to represent the case before the UPC, you have to admit it to a court of a contracting member states. Well, the UK lawyers admitted in the UK do not qualify in that regard, because the UK is not a member state. But many UK lawyers are also admitted in Ireland, so they are waiting for Ireland to join. At least that's what I heard, what rumors tell me. And then you have three in the very bright blue: Spain, Poland, and Croatia, who haven't neither signed nor ratified the UPC agreement. So we wait and see what's going to happen there. There are different reasons for this. I don't want to go into details. It's also a bit of a political issue. And the green tells you where the local divisions are. So what you can see is that Germany hosts 4 local divisions, while all other member states, not all, most other member states host 1 local division. You may ask why Germany has so many local divisions. That's partly because already at the moment the patent litigation happens to a large extent in Germany, but also part of the story is that all states that host a local division have to pay for it. So they have to pay during the transitional period for the staff, for the building, for everything. So also, in that regard, Germany has to pay for 4 rather than just 1 local division. Very briefly turn to the competence of the UPC. It is essentially all kind of litigation you can have with regard to a patent. So it's infringement, action for infringement. It is action for revocation, counterclaim for revocation as part of the infringement action. It is action for damages, and of course it can also be preliminary measures, so in particular preliminary injunction. And also actions concerning the grant of a unitary patent. So now turn to the composition of the panels of the UPC, of the judges. So who are going to be the judges? Well, there's something, I guess, that is unknown in Brazil, to my understanding, that the panels will, at least by most of the cases, they will have a technically qualified judge, not only legally qualified judge. So that, and of course, a technically qualified judge from the field of technology concerned. So when the patent is about electronics, then the technically qualified judge will have a background graduated in electronics, and the same with chemistry and so on. As to the legally qualified judges, they are mainly judges that are already known to the patent community, put it like this, because they are mainly experienced patent judges from the member states. And what is also interesting is that only a few of them at the moment have a full-time job. Most of them are only part-time, so they have 2 hats. They have a hat as a national patent judge and a hat as a European unified patent court judge. And the idea is clear that at the beginning you do not expect so many cases, so it is part-time position is enough to deal with all the cases. So the system does not want to have judges without any cases. So as soon as the cases are growing, already with 50 cases we are not doing so badly, then the work time of the judges will be increased. That's the concept, to have a flexible concept with regard to the demand in that field. So I think I can leave it there. Don't go more into this. Maybe one more point. Even if a local division is hosted in a member state, for example, in Paris, this does not mean that the judges have French nationality. So in practice, always at least one legally qualified judge is coming from another EU member state. So in the example of France, you will have at the beginning 2 French judges, but one coming from another country. Ideally, of course, also speaking French language. So maybe someone from Belgium, but depending on the case. And the same goes for the divisions hosted in Germany and so on. Well, language. Language is, of course, an issue in Europe. In Brazil, you are lucky to have just one language. I heard the Brazilian spoken in the north is a bit different from the Brazilian spoken in the south, but still you understand each other. In Europe, it's not like this. German is only understood by some Europeans. French is only understood by some Europeans. Normally, the language of communication is English. And so what is the language before the UPC? Well, the UPC, to some extent, has to take into consideration the idea that all languages, European languages, are in principle the same. However, also needs a pragmatic approach. And on that basis, when you now bring a case to one of the local divisions, you have the claimant. The claimant can choose between, as a language of proceeding, can choose between the official language of that state. So when you look at the Paris division, you can decide have French, and alternatively English, because France has decided to also allow English as language of proceeding. And the same, in principle, is true for all the local divisions. Always, for example, before the division in Milano, Italian or English. In Germany, German or English. Now, stages of proceedings. Well, it is essentially, I think, very similar also to the Brazilian proceedings. It starts with a written procedure. What is important to as a takeaway is it is a front-loaded proceeding, which means all the facts have to be submitted in the written procedure. You cannot come with new facts at a later point of time unless you have a good excuse for this. Then also deadlines for written submissions. Then there is an interim procedure. 2 purposes of the interim procedure. First, preparation of the oral hearing, for example, summon of witnesses or summon of experts, but also exploration of possibilities to settle the case. And then at some point of time you have an oral proceeding, which I guess will happen roughly the same like before a Brazil court here in Brazil. Could be a preliminary introduction by the judges and then the pleadings of the parties, and the court should endeavor that at the end of the hearing the court is able to decide the case and don't have to have a second hearing. Video conferencing is possible, but principally it should still be in the place of the local division. But for example, if parties come from Brazil, don't want to travel, they may, through their lawyer, ask for permission to join remotely. And then the court may grant permission for this and also have access to their respective video platform. Then public access to the register. So in principle, one can look into the register and see what is happening. All decisions and orders will be published, but only on demand. Third parties may also have a look into the files. Protection of confidential information, which is important in SAP cases. While confidentiality clubs is available, representatives and at least one national person from each party, however, have to be part of this confidentiality club. Pre-trial procedures, US style, no. Europe does not have a pre-trial which require a lot of money and time, so this is not going to happen. Experts, Party experts are available, so parties can bring in experts of their own. Courts can also appoint a court-appointed expert, but my expectation is that this is not going to happen very often, since there's already a technically qualified judge on the panel. Permanent injunction. Well, there's a discussion about proportionality. eBay, European courts don't have the eBay test. We learned about the eBay test yesterday on one panel. Europe has the eBay test, but may have a kind of proportionality test instead, which is a bit softer than the eBay test from the US courts. And award of damages, well, 3 ways of calculation, but no punitive damages like in the US. And then finally, uniform format of orders and decisions. You have to keep in mind the judges have all background, a national background. And just the format of a judgment is different. For example, in the German judgment, the part where the order is, so you are ordered to do this and this, is at the beginning of the judgment. While in France, for example, it is at the end of the judgment. So you have to decide which way to do before the Unified Patent Court, because you cannot have it in the division in Paris this way and the division in Munich the other way round. So it's a bit like traffic in the street. You have to decide: do you travel on the right side or on the left side? So these kind of decisions have been taken, and so there's suggestions for a uniform format for decisions and orders of this court. And these formats, these templates are publicly available. When you go to the website of the UPC, you can easily find out about this, as many other legislative pieces. If you want to have any information, go to that website. And maybe a final slide with a few photos. Here you see a few court buildings where the UPC is located. When I'm in Europe, I usually do a test at this point of time, asking, well, do you recognize the courts? Maybe here in Brazil, it's a bit more difficult, so I just tell you where it is. So when we start in the first row, the first picture shows you the regional division in Stockholm. That's Stockholm. It's like a castle, medieval castle, but it is not a medieval castle. It was built in the 19th century. The next one is the building of, and it does not, of course, not only host the UPC, also other national courts inside. That's the building of the Vienna local division. The next one is the Düsseldorf local division. And then the first one in the lower row, I guess some of you know. You have an idea where this could be? That's Paris, that's Ile de la Cité. But this is not in the building you see, but it is a look from the court building on Ile de la Cité. The next one is the Court of Appeal in Luxembourg, which is the former building of the European Parliament, which is now used also for the UPC. And the final photo shows you the local division in Milano. And I've come to my end. Thank you very much for your attention.
Dr. Grabinski, thank you very much. Mesmo que sou inglês, meu coração é brasileiro.
My heart, I'm going to speak and mix up Portuguese and English, and I would like to let's learn a little bit about the cases that have already been started in the court. As Dr. Grabinski has said, we have more than 50 proceedings that have started. We will analyze them. I don't participate in any of these proceedings. The UPC patents is very respected. I say this because it is used by most of the greatest companies in the world. Let's see revocation proceedings, provisional measures, and infringement proceedings. Let's start with revocation. There are more or less 6 pending actions. I say more or less because it's not possible to always. I said 6 pending actions because it's not possible always to see everything that is in the register of UPC, not for the members of the public yet. So let's start with life sciences. Everybody knows Sanofi Aventis. And now I'm going to speak in English.
A medication for lowering cholesterol, para baixar o colesterol. Mas é patente bem velho.
I'm sorry,
Divisional application, and it has been subject to a lot of litigation around the world, particularly its US equivalent. Now, what we have to see here, in the US, the action was initiated back in 2014 in the District Courts of Delaware, but has most recently, on the 18th of May of this year, the Supreme Court of the United States released their decision, finding that this, the US equivalent patent, indeed is not enabled. So there's a lack of sufficiency. So we can see that there's already, Sanofi Aventis is using the UPC to attempt to invalidate the European patents in the contracting states in Europe. Now, an interesting part about this also is that this granted patent is still within the opposition period of the European Patent Office. And if you recall, then an opposition may be validly filed within 9 months of the grant of the European patent. And so what we have here is the potential for parallel revocation actions and opposition actions. This is not possible in all European countries. And so this brings a new flexibility in combating, in this case, or nullifying European patents. The next case we'll have a look at briefly is this nanostring technologies. You're going to see these names quite a lot because what we have are that many of the claimants, the plaintiffs, are also the defendants in other cases before the UPC. Here we're thinking about detection of labeled species, it's biotech area, but we've got already a lot of litigation across the world, particularly in the US, as well as in Europe. And the Astellas case I won't talk about now, but what we'll do is move on and look at some other cases in the medtech and other areas of technology. In Merrill and Edwards Life Sciences, again, there is litigation across Europe, the UK, Germany, France, Italy, Netherlands, continuing through, as well as, of course, in the US. And again, what we'll see as we look at the revocation actions, the preliminary injunctions, and the infringements, we often have the same parties appearing. Here, Merrill and Edward Life Sciences. This patent was not opposed back when it was granted by the European Patent Office in 2021, but this is again another important aspect of the UPC. Even when the patent has not been opposed, you can still bring an action for revocation which will extend across many of the European countries. Of course, the revocation, the nullification, will only take effect in those countries in which for which the claimant requests, and also only those in the jurisdiction of the UPC, as Dr. Grabinski has explained in detail. Now, I'm going to look at briefly Bitzer Electronics and Carrier Corp. And you might think, why is this case of interest? Well, this relates in fact to an apparatus for cold chain monitoring. So checking that food is kept at a good temperature during transportation. Relatively large companies, turnovers, Bitzer is about 1 billion euros or dollars, Carrier Corporation about $20 billion. So still sizable countries. The interesting part here, and this raises an interesting legal question, is that the action for revocation was filed at the end of July, on the 27th of July, but this patent had been previously opted out of the exclusive jurisdiction of the UPC earlier on the 13th of July. I can't see that the opt-out was withdrawn, so this raises an interesting legal question, which I could ask Dr. Grabinski to answer, but it's a pending case and I don't want to, the courts will have to discuss this in detail. Yes. So, where should we go from here? Well, let's look at some provisional measures. These all really relate to preliminary injunctions. Again, we can see some of them on the public register. And we're going to start with some parties, claimants and defendants who are already familiar to you. So this 10x Genomics relates to Harvard University. Now, interestingly here, what is so good about this patent, the EPE 4108782, this is actually one of the first unitary patents to have been granted as a unitary patent on the 7th of June. And there are now more than, I think, 6,000. I think I looked this morning, and we have 6,862 unitary patents have been registered, and a request for about another 410 that are being processed. So this is the first case of a unitary patent being enforced before the UPC. There is going to be an oral hearing, a summons for the 5th and 6th of June, 6th if it's required, and if you're interested, you can actually attend in public. They've already set out today plans for, if you are members of the press, where you can go and sit. There's another related patent, again in relation to a preliminary injunction, and the hearing for that is going to be on the 19th of September. So the actions already, the court is already functioning. In the Merrill Life Sciences case, again interesting because there is a protective letter, a protective writ on file. This relates to, in fact, all the Edwards cases relate to heart valves, válvula para coração. And there are many patents and many devices in dispute here. A hearing date has not yet been set for that. This one perhaps is very recent, the Maestroma case. It relates to bicycles, electric bicycles, in particular the rear hub, if you're into mechanics. And what was really demonstrates the speed and efficiency of the Unified Patent Court is that in Frankfurt on the 21st to 25th of June was an international Eurobike cycling exhibition. The preliminary injunction was filed on the 22nd of June, so one day after the start, and very quickly, in an ex parte hearing, the UPC, the local division in Düsseldorf, issued then a preliminary injunction, and the bicycles from the defendant from Revolt Cycling were removed from the exhibition, and the website also removed. And this was despite a protective letter already being on file at the UPC. So what we see here is that the UPC is very reactive, very responsive to requests for preliminary injunctions. So moving next is to actions for infringement. And what we have here are at least 33 actions for infringement. Some cover just one country, for example, just Germany, but others extend across many states, and we have up to 10 co-defendants in one particular case. We also have parallel proceedings, parallel EPO opposition proceedings, and of course the proceedings before the UPC. So what we are seeing is that the UPC is being used correctly as a forum for, I'll call it negotiation, settlement in some way of these contentious proceedings. And we'll see that it has already been effective in achieving this. The first we're going to look at, you remember Amgen and Sanofi? Well, this, if you remember, there was the revocation action filed by Sanofi for exactly the same patent. It was filed before this infringement action was filed by Amgen. What we have here is a value for the case of 100 million euros. Now, before the UPC, you're required to pay an official fee, For revocation, it's a flat fee of 20,000 euros. For preliminary measures, 11,000 euros. But now here, when it comes to infringement, there is a base level and then a value added amount. The base level, I think, is 10,000-ish euros. Here, in this case, because this value of the case of 100 million euros for this infringement action, the official fee is some 336,000 euros. So a relatively high official fee for this case. It means that it's important. This case is being extensively litigated, as I said, already around the world, particularly in the US, where we have the Supreme Court, the US Supreme Court decision. 10x Genomics, Harvard College, we're familiar with again. Just to give you an idea, a relatively lower value of 10 million euros translates to a lesser fee of 76,000 euros. Remember again that this is the first unitary patent to be enforced also before the UPC, where we also have the summons for the preliminary injunction in September. Moving through, the familiar names of Edwards, Life Sciences, and Merrill are appearing. And here, in fact, two cases being asserted at different courts in respect of different patents. So Edwards, Life Sciences being represented by UK lawyers. Indeed, there are some more than 800 European patent attorneys who are registered to represent from the UK before the UPC, as Dr. Grabinski has said that we can continue to do, and we will continue to do. So these disputes, Edward Life Sciences, Merrill Life Sciences, these continue across the world, and they have chosen to use the UPC as the forum for their dispute resolution or settlement or final decision. Moving through to another large action. This is Ocado, it's a British company, and AutoStore, which is a Norwegian company, and it really relates to robotics. The actions for infringement and counterclaims first started in the US back in 2020, and they have continued through in the US courts, in the German courts, in the UK courts. And what we had here is the UPC being used probably to a full extent, where Ocado is bringing actions for infringement to multiple defendants in multiple countries. So really using it for the cross-border purpose that it was originally intended, and it continues to be used. Now, the action for infringement was lodged in June, on the 16th of June, and what we had announced more recently, on the 22nd of July, so some 5 weeks later, is that AutoStore and Ocado had come to a worldwide settlement in relation to the patents, and this requires that AutoStore will pay to Ocado some more than 200 million pounds, $250 million over the next 2 years. So this is demonstrating again the use of the UPC, the value of the UPC, the respect for the UPC, in order to encourage claimants and defendants to settle. And this is one of the particular advantages of it, because it is already a respected court. I think I have a couple more cases we're going to look at quickly. Mystroma, we have already seen, they got the preliminary injunction that was granted. They have now brought out very recently an action for infringement with respect to Revolt, and indeed a natural person. The value of this case is relatively lower, some 750,000 euros. I think the current lowest value case we see on the UPC is some 250,000 euros. But just to give you an idea here, the official fee for this case is only 13,500 euros. So it compares, with the more than 350,000 euros for the Amgen case, which was valued at more than 100 million. But this, of course, will continue. Here, the patent was actually only validated in a few countries, but it's being asserted then as broadly as it can be. And finally, I will just touch on a couple of related actions. On the 31st of July, Panasonic lodged indeed 11 different actions before courts, primarily in Germany, in respect of 5 and 6 patents against Oppo, and I'll bring in the other one because it's also relevant, Xiaomi, and these relate to 3G and 4G technologies. These are all standards essential patents. Now, Panasonic has, through bilateral negotiations, negotiated licenses with everyone else, but the UPC here is being used as a forum to better negotiate the licenses that they still do not have with Oppo and Xiaomi. So we have then these 11 cases, including a total of 6 patents. The value is relatively low. This, the 20 million that is here for Xiaomi is a cumulative for the 5 different patents, so 4 million apiece, meaning that the official fee is about 30,000 euros per case. And what we also know is that on the 9th of August of this year, so about 10 days after lodging of these cases before the UPC, Panasonic announced their worldwide litigation program in the UK, in parallel in Germany, and also in China against Oppo, against Xiaomi, for these standard essential patents. So, what do we really take away from this and thinking about the benefits of using the UPC, this already respected forum for disputes relating to patents? Well, what we have, whether you are the claimant or whether you are the defendant, you have now a single proceedings. Rather than having proceedings in multiple countries, we now can focus on a single proceedings, even for multiple states. And you can join together multiple defendants from those multiple states, including outside of the UPC contracting member states if it relates to infringement. As Dr. Grabinski has explained, we can have now also a single language, the language either of the court of the country, or if it's agreed, it can be in English, which really facilitates and is perhaps a reason why many of the companies, for example Panasonic, have chosen the UPC and continue to file the actions in Germany, but they may have the proceedings, for example, in English. And this all then brings to, you have a single legal team at the UPC, whether you are actioning in one country or in multiple countries. So this brings about it then the economy of having then single proceedings in a single language with a single legal team. Thank you very much. Moderadora.
Very much. That was very interesting, Howard and Klaus. We're very excited to see how that continues to work, especially in Brazil. We have a little bit of a slow litigation. We're still litigating some cases, a few cases, of course, but still on DVD and CDs technology. So to learn that we have such a extent of reliefs and decisions up to 17 countries and with such a speedity, how fast can you get a full disclosure and a final decision in cases?
Does it work? Yeah. Okay. The idea is to have a case on the merits finished within 1 year. However, I have to say I'm a bit skeptical at the beginning, since everything is new, there's no case law. Of course, we have case law, the UPC can build on case law of the national courts, but still there are provisions of procedure that have to be explored and to be applied. And the court is an electronic court that also has some difficulties. Judges have to get used to it. The system still needs some further developments. So I guess maybe it will not, the first case it will not, on the merits will not be decided in 1 year, maybe a little later. But again, it also, of course, depends on the complexity of the case. So when you think of the case with the 5 or 6 patents, then of course that might take longer, or it depends on the judge, but the alternative might be that the judge or the panel tells the claimant, okay, let's focus on the one or the two best of the five. So and then we can do it a little faster with these two rather than have five in parallel. So there are different ways how to deal with this. So all in all, I expect it to have a decision on the merits in a bit more than 1 year.
That's great. Does anyone in the audience have any questions? We do have one. Right here, please.
Oh, Dr. Grabinski, thank you very much for your presentation. Howard, too. This is a very interesting theme for us, even here, although we are distant from the reality in Europe. We had a chance to talk about the issue of the languages. And I read those days there was one philosopher who said that life is too short to learn German. And then I wonder how it will work in practice. Like you have an action brought up in Germany, and if it was me, I would file it in German, even if if the defendant was outside of Germany. They might be part of the strategy to make things more difficult. So is there any plan to mitigate this issue of the languages, and how does Howard see this possibility?
Yes, probably it will remain for long now, as it has been said now. So the local divisions, essentially you have the language of the place or alternatively English. And when the claimant chooses that it should be the language of the place, so if you bring it for a local division located in Germany, then it would be German, then it is German. However, the situation is not different from what we've seen in the past, because there were many litigations brought before German courts where the parties were not German companies at all. It could have been a US company against a Japanese company, an Italian against a French, whatever. And in these situations, always the parties, probably, I guess that's not completely clear, of course, for a judge, but normally the lawyers or the patent attorneys they have in their respective countries, they are connected to lawyers or patent attorneys in Germany, and then they arrange for respective representation in the courts. And so in principle it's not different now. Maybe it's more a problem for the court, because when you look at the local division, there you have two judges from Germany and one from another country, and the president of the Court of First Instance, which is a very nice French lady, she then gets a third judge who is also language skills in German, if the language of proceeding of the case is German. So maybe a judge from Austria, from the Netherlands, whoever speaks German. But when then the case is appealed, at the appeal level we have currently two divisions, both of which have one judge from Germany, and then of course judges from other countries. But these judges, some of them speak some German, but are not possibly perfect, and some don't speak German at all. So probably that might be a problem then for the court to deal with this. But after all, we learned from the AI session that we have wonderful translation tools now, and that's true. I don't know whether you do it. I use it quite often, and you always have to check, of course. There's someone who's check this, but still, this is of a lot of help, and will also be a lot of help for the UPC judges.
Anyone else with questions?
Good morning, everyone. Howard, congratulations on your Portuguese, really impressive. Klaus, I saw from your presentation there is a mediation center, an arbitration as well, but I'm more interested in the mediation one. Is it already working? Do you expect to have a lot of cases? Because sometimes in those patent, complicated and complex, litigation like the SAPS litigation and so on, maybe mediation will be the main resource in the future. You already have something? Did you receive something at the UPC?
I have to admit, at the moment, this is not yet in place. The court had to focus on the court. But it is required by the agreement, so we're going to have it, and we are now focusing on establishing this. Actually, it is one center. It's arbitration mediation is the same center, and but we have two places where it's going to be located. It's either Ljubljana, which is in Slovenia, or it is going to be Lisbon in Portugal. And I'm quite confident that at least in 2024 this is going to be up and running and then available for mediation or arbitration purposes. If parties would like to have it, and particularly in SAP cases, that might make a lot of sense. Yeah.
Great. Anyone else? Maybe you have time for one more question. That one. So we should finish as well. Then thanking very much for the speakers for such great presentations and for being here. We know that Brazil is not in the middle of your way to anywhere, so we appreciate that you came all the way to Brazil to make those important and great presentations. Thank you.
Thank you for your moderation.
Muito obrigado.